Thank you, Andrew. Andrew will now receive questions.
What do you think about us becoming executors and trustees?
I think that it is something that I've become more and more comfortable with, both advising clients, advising partners or referrer of partners to take that role, and also advising clients of the potential benefits of that. That's been a change in my perspective. When I started out in this area, I was biased against it, because I was sort of brought up in the context where you want to control everything. You don't want advisors involved in your affairs, and they're in there for the fees, and you can't get rid of them, all that sort of stuff. But as I've seen these things play out, and I've seen the important role that the advisors can play in making this actually a less painful and more controlled process of the wealth transfer, I'd be more comfortable suggesting to a client or working with an advisor to put that in place. You need the checks and the balances, and I think obviously the conflict or the potential conflict needs to be fully disclosed. There needs to be protections within the document to be able to remove the advisor and keep people honest. It needs to be a conscious decision, and there needs to be full disclosure with the client. And there needs to be a deep relationship between the advisor and the client. I wouldn't put myself in there if I didn't know the client or didn't have a relationship with them. So for those who've got those relationships, who are willing to take on it's a serious burden, then I think there's a lot of value to be added, and I think we're going to see more and more of it. It's something that internationally has been around for many, hundreds of years, literally. I practiced in the UK for a while, and it was a very common feature of estate planning and wealth management, both from the advisor perspective and also from the sort of trustee companies and professional trustees. It is definitely more and more of it is happening in Australia, and I'm biased towards it now as opposed to biased against it. And it's fantastic from an advisor's perspective if they are the right person for that role, as far as, once again, deepening that relationship and having a continuing relationship.
We still got a few minutes for questions. We'll finish at 9.
Mel.
How often would you recommend that the advisors write letters because of the changes in laws? Is it a 5-year process? Is it every 3 years? Is it every 12 months?
I think the more you know about your clients, the more you can answer that question on a client-by-client basis. So if you have captured the data that says that the client has children under 18, the client has a self-managed super fund, that the client has the family home owned in a certain way, the client has a will that has these particular things in it, then when something happens, you can say, okay, all the clients who are in this particular scenario now should receive something from us. That's a level of client knowledge that certainly most lawyers I know don't have, because they don't think that way. At the other end of the spectrum, I think financial planners are very good at that, about understanding those attributes of their clients. I think probably accountants are in the middle. Obviously, that's a very broad generalisation. So the answer to your question is, if you don't know about your client, then start to gather that data through the current periodic review, which might be an annual thing. But once you know your clients better, you can really start to target them with issues and changes that the last thing I want to get is an email that is just not relevant to me. We all hate that. And really there's no excuse for it anymore, because we all have the ability to have the tools to understand our clients better. So it's sort of a long-winded answer, but that's a good question.
So you're suggesting that your fee be rolled into the one item when we as advisors with intermediaries when we deal with clients.
It depends on the relationship that we have with intermediaries. We have some where we will package it. Either we will invoice and including their fee, or they will invoice including our fee. Obviously with full disclosure, so everybody knows, the client ultimately knows who's getting what. But yeah, because of the fact that we know what we're dealing with before we start to deal with it. And some of the people we work with, we know, they're actually helping us really right up to the document sort of review stage almost. And obviously that's making us much more efficient. And we can, as you'll see from our price guide, we're about taking away price uncertainty so that we can deliver these things. And people, it's an old saying, you probably all heard it, but architects and building companies can build a 100-storey building and they'll give you a fixed price, but a lawyer can't give a fixed price for a will. That's just not acceptable. So how you present that to your client is really up to your relationship with the lawyer that you're working with, and also how you approach your clients. Whether you might have a fixed fee with your clients, in which case you're saying, as part of your annual fee, estate planning is now going to be part of it. This is what we're going to do, and it might be in the context of negotiating a fee increase to your fixed annual fee or something like that. And then the lawyer's fee would be separate. For clients where you're doing estate planning as a separate type of fee arrangement, then you've got those options. Yes?
Rolling superannuation, whether it's self-managed or otherwise, into an estate, how do you go about the mechanics of that?
As a rule, you've got a few gates that you need to go through. So the first gate is, do you want it coming into the estate or do you want to go in directly to a super dependent? If it comes into the estate, then we generally have a schedule or a provisions that deal with superannuation. And as a default, there would be some sort of discretion for the executors to deal with that superannuation in the most tax effective way while still achieving the outcomes that the client wants to achieve through the will. So following that, the client's objectives, but doing it in the most tax efficient way from a super perspective. It's a big question, but that's sort of our default. If there's no possibility of challenging wills, and it's a reasonably straightforward scenario, our default would be a non-binding nomination to the estate and then deal with it through the estate. It's just that if it goes direct or whatever, then you've just got the additional complexity of doing effectively notional estate adjustments within the will and all that sort of stuff. So our default, that's a very broad statement to make, but our default would be non-binding. The reason non-binding, in case something has changed, then you might want to go direct to a super dependent. But then if it's non-binding and it's a self-managed super fund, then you've got to worry about the control structure for the super fund, so that then you might use a binding nomination. So there's a number of different things that would go into the mix, but that would be our starting position.
I thought the clients want to have some estate planning. They usually they want to have this and that. So what's your firm's input like? Do you give advice?
Say, for example, my clients come to see me, estate planning. They have a list of wish what to do. And if we put forward to you, what is your input to their planning?
Yep. So I'm assuming that what you would be putting to us is the background of the client and what the client's told you that they wish to achieve and their concerns and their objectives and those sort of things. Mm-hmm. Our input is really at two levels. First of all, we would be talking with the client about what sort of strategies they might want to adopt, the pros and cons of those strategies to achieve those outcomes. And that actually might have the effect of them saying, you know what, I actually don't want to achieve that outcome. It's not, if I have to do all of that, etc., then I don't want to do that. Or they might say, yes, I'd like to go ahead with that. So there's an initial problem-solving element to what we do, and then there's a documentation element to what we do. So once we have settled on those objectives and the outcome, then we would then document that.
If you have a testamentary trust and where, of course, if someone does pass away, the sub-trust is activated, is it okay to have that beneficiary as also the trustee of that trust?
It depends on what you want to achieve. A beneficiary controlled trust has sort of been a default for testamentary trust for some time because people were generally putting them in place for tax purposes. So they didn't really care about the control and administration structure for the trust. They were just caring that they set something up, they gave complete control to the beneficiary. It was all very straightforward. But I think when I talk about testamentary trust with clients, I don't think I've mentioned tax in 2 years, to be perfectly honest. Because what they're using testamentary trust to achieve is usually some sort of control and administration of the estate. It's trying to achieve some objective other than saving tax is just a benefit. And when you try and solve other problems with testamentary trusts, other than just getting a tax benefit, you need to think about who's the beneficiary, who's the trustee, who's the appointer, is there a protector, what are the release conditions, and a whole lot of different factors come into play about achieving the outcome you want from that trust. If all you want's a tax outcome, then you might just have the beneficiary as the trustee and that's the end of it. But as I say, that's quite rare now in a lot of the stuff that we do. Does that answer your question? Thank you.
Thank you, Andrew. Thank you, Tom.